Citrin for I was the trial lawyer below, and I would ask the court to reserve 2 minutes for rebuttal, please.
Okay, if you'll keep an eye on your clock there.
Yes, sir.
We'll let you know, too.
With me is Rebecca Mercier Vargas, who authored the briefs in the case, and attorney Jesse Farber, who was assisted me in arguing the issues of law at trial. Mr. Farber? So, first issue we'd like to address is on retrial in this case. We feel that we cannot get a fair trial from this judge. And the issue is whether a reasonable litigant would believe that a judge who sat there with counsel out of the room and carrying on a conversation, degrading the strategy of her own counsel, whether that creates at least a reasonable belief that there would be prejudice on the part of this particular judge. And the Supreme Court has referred to our trial courts as a temple of justice. And when there is critique and criticism in front of a client whose daughter is brain injured and has the mentality of a 5-year-old who's now 30-something years old.
We have to obviously reverse to really make this relevant, right? What is this judge even? Isn't this judge retired?
No, she's active.
Is that okay?
Yes, she is.
Still active and stuff. Okay.
Yes.
Let me ask you this. As Judge Gross's question points out, we don't get to this issue if we affirm everything. But let's say hypothetically we reverse on one or more points. Would I have done what Judge Henning did? No, I don't think I would have. Or, most importantly, if the attorney for the defense had initiated this conversation, I would have said, and particularly she saw Ms. Lenhart was there in the courtroom when this happened.
Yes, sir.
They say, this is not appropriate. I can't discuss anything with you. But it's not asking her to prejudge anything. It's almost like a post-mortem on, and I guess it was your argument, something about double dipping, and he said that was confusing, and she agreed with him. Assuming that we agree that it's inappropriate, I guess what we're looking at is a harmless error analysis. Would it have any impact on anything if the case goes back for retrial?
What about the impact on my client, the impact on the perception of the judicial system, that is it acceptable for a trial judge and a defense lawyer to sit there and carry on a conversation in front of a catastrophically injured client's mother? And what is her perception? Is it reasonable to believe that there is going to be some bias there on the part of this person? And it's our position that clearly this is improper. We're not taking this up in the middle of the proceedings. We're taking this up at the end of the case. And if and when Your Honor's reverse, we would ask that a new trial judge be appointed with one sentence at the end. There doesn't have to be any detail as to what she did. With regard to the next issue, which is the jury selection issue, we have a juror who I had to use a peremptory challenge on, and of course I preserved everything. And this particular juror said his son turned into somebody, which is exactly what happened. And he said, we are being sued due to his wreck, which is exactly what was happening to the defendant here. His son got ticketed, and he said that he believed his son, who said the other driver caused the accident. And he was one of a couple, 3 jurors who said, I said, how many of you feel bad for this defendant being sued? He was one of the jurors who raised his hand and said he felt bad. So he also felt there should be a limit on damages and tort reform, and that, of course, in and of itself doesn't do anything. But the key here, other than the fact that he equivocated 7 times with 2 I hopes, 3 I think, 1 I don't know.
Yeah, but look, I mean, I understand all that, but this, you're focusing very closely in your brief on that language, and sometimes somebody's saying, well, I think, they're using those terms in a manner which if you actually see them and are on site, you kind of understand a different meaning than you're trying to ascribe to them. The trouble is, in this situation, shouldn't we defer to the trial judge who is on site to really make that decision rather than focus on the words without seeing that particular juror? Because, the trial judges, we have to rely on them to do the right thing on these types of things.
Well, we have to, but that's what the appellate panel is here, of course, for. And in this particular case, first of all, I argued in front of you 15 years ago in the Goldenberg case, where this court reversed another case where a juror answered equivocally at best and was never rehabilitated, and Judge Pariente, Justice Pariente, now wrote that decision. But the key here is, I asked him, and I didn't put any words in his mouth. I said, in this case, this also involves a term. Would you tend to favor the defense if that's the case? Would you kind of put yourself in their position because it might be, and he cut me off, and he said, I hope I could be reasonable. I mean, in the back of my mind, it sounds like it may be a similar case. I don't know. This juror was never rehabilitated. He never said he could follow the law, and in fact, he became antagonistic at the end of questioning by opposing counsel.
Counsel, let me redirect you, because if you get a reversal, then the juror issue is immaterial, and Ms. Mercier knows this. I don't think you do as much oral argument as she does. Purpose of oral argument in the 4th District is to answer our questions. And I have a lot of questions about the helmet issue.
So that's your best, I agree, that's your best issue. I mean, that's really where we should focus our time. I agree with you.
At the time of this accident, was there a statute in place that required her to wear a safety helmet?
There was a moped statute that the trial court did not give a jury instruction on that we specifically requested in writing. And that statute said that anybody under the age of 16 had to wear a helmet. So by necessary implication,
She was in her 30s, right?
she was 27-ish, yes, sir, for all intents and purposes, yes. So that was one thing. In addition, there was a jury instruction on the motorcycle statute that said that if you had $10,000 worth of insurance, then you did not have to wear a helmet in the state of Florida.
See, what I don't understand is they're equating this to the seatbelt defense, but the seatbelt defense is statutory. Clearly, whether or not she wore a helmet had nothing to do with who caused the accident.
Your Honor, that we...
I mean, that's not an unfriendly question. So my point is, how do you even get to comparative negligence because she's not wearing a helmet? They can argue, I'm sure, to the jury, she wouldn't have been hurt so bad had she been wearing a helmet, but I don't know how they get to apportion fault based on that.
And there is nothing in the state of Florida that says that that fault should be apportioned. In fact, the legislature has shown that when necessary, they'll speak to whether it should be considered comparative negligence, and they did that on the seatbelt statute. They have not done this, and they said for bicycles, for mopeds, if you're bicycles, you don't have to wear a helmet. It's not comparative negligence, and so I agree with Your Honor 100%. Should not have been an issue in this trial. But more importantly, what should have been an issue was the defendant's failure to wear his eyeglasses, and he admitted that his vision was not too good when he was driving.
I think his response to that is he couldn't remember.
Well, if somebody can't remember when they turn into somebody who's thrown 20 feet in the air and is comatose and lying there bleeding, and when they testify at their deposition that they cannot remember whether they were wearing their glasses, there's a case on point from another jurisdiction that I filed in my supplemental authority. That's number one. And number two, It goes to the weight of the evidence for the jury to make that determination.
What about, there were other kids in the car, right? 3 or 4 other kids?
There were other kids in the car, they're drinking, they're smoking pot, I mean, but.
Yeah, but
we
none of them knew whether or not the driver was wearing glasses?
Well, remember, he was an unlicensed driver, which
Right.
also should have been told to the jury because his.
Let me try again. Were the other occupants of Besorra's car deposed?
Yes, they were.
All right. Were they asked, was Mr. Besorra wearing glasses when this?
I don't recall the answer to that, and my best remembrance and memory is they were not asked. So there was,
The other issues connected with Mr. Besorra, I think you got an argument, a good argument. I want to hear from your opponent why he thinks the trial court was correct not to allow evidence that A, he had no license, B, the only other time he had driven a car was when he was 13 years old and he went on a joyride, and I think there was one other aspect of his lack of experience in driving a car.
and as Your Honor points out, that's the Dorset versus Dion case, where the court held that the fact that the person had a permit, this individual didn't even have a permit. In that case, the person had a permit, and the court held that evidence of her inexperience was admissible in that case.
I have a series of questions on, I don't see, I mean, first of all, before I get to those, I don't see that you've raised an issue in the appeal that it was error to charge your client's comparative negligence in the first instance, because the law doesn't require to wear a helmet, that it wasn't evidence of negligence. So have you waived that issue by failing to raise it in your brief?
Your Honor, here was the problem. There were about 12 errors that we felt were reversible in this case. We know, and appellate counsel advises, and we know that you all don't want to see 12 errors pointed out in the briefs, and we know the briefs are supposed to be succinct. So we went on the ones that we felt.
Okay, so you made a choice not to raise it in this case?
Yes, sir.
Okay. Okay, I have a couple questions. Some of them are very easy, and some are, a little more difficult on the issue of whether or not the jury should have been charged on this. Your best case, it seems to me, and it really would be a winner if we choose to follow it, is Metropolitan-Dade County versus Cox. Number one, I don't see that, has this court adopted or followed Metropolitan-Dade County versus Cox, or has the Supreme Court of Florida adopted the reasoning of Metropolitan-Dade County versus Cox in any case?
Well, I don't think per se that Judge Schwartz's opinion has been adopted. I think that one other court referred to it, but the same concept applies in the Ridley versus Safety Clean case.
And I looked at Ridley versus Safety Clean, and the same concept does apply, but I don't see, there was no reference to this, and there was no reference in Ridley versus Safety Clean to what I would call the mechanics of comparative negligence. So these are a little more difficult. I'm going to put you on the spot here. I've been struggling with this case more than any other case like this week to sort of grasp some of the issues, because I understand, the arguments on both sides. So I found this law review article. And the law review article breaks down comparative negligence in an analytical way that I think is helpful. And in doing that, I'm going to ask you to respond to some of the things in the article. And I know I'm putting you on the spot, but it really involves whether we should follow Metropolitan-Dade County versus Cox. And I want to define blameworthy means that under this article, the author defines blameworthy as a failure to meet some standard of right conduct, such as negligence. Okay? And so the author then goes on to say, really, and he splits it up into 3 ways. But the first way is that, looking at comparative fault, is that apportionment under comparative fault is based on blameworthiness. Okay? The degree of negligence and so forth. And if that's true, that's clearly the approach of Metropolitan-Dade County versus Cox. No question about that. However, the author says another way to look at comparative fault is really to apportion fault by by causation of loss, that it should have priority over blameworthiness. Now, causation of loss finds support, I think, in the jury instruction. Not really in any case that I've been able to find in Florida. So this is what I want you to respond to. The author thinks that apportionment of fault and comparative negligence by causation of loss is preferable for some of these reasons. Since no one should be liable for more harm than he causes, causation rather than blameworthiness should be the primary basis for the extent of liability as well as the fact of liability. Further, apportionment by blameworthiness, i.e. the Metropolitan-Dade County approach, is inherently subjective and arbitrary. But apportionment by causation of loss, since it is possibly only if there is a reasonable basis for determining the contribution of each cause, is objective and rational. Apportionment by causation of loss involves a lower risk that decisions will be based on prejudice or caprice. Okay, so that's like the argument that really supports the other side. And what I guess I've been struggling with here is, I don't, on the one hand, if we follow Metropolitan-Dade County, this to me is a clear reversal, and we would only be talking about whether it's a reversal under our cases or a new trial on damages, or it would be liability only. I think that's a great case for you. But if we decide not to follow Metropolitan-Dade County and follow, a causation-based approach for comparative negligence, we would certify conflict and let the Supreme Court decide. But what's wrong with, I know I'm putting you on the spot, but what's wrong with the analysis that the author made for the preference of causation of loss being a preferable way of doing comparative negligence in Florida?
Yeah, and am I okay on time? Because I'm over?
Yeah.
We'll give you a little extra time.
Thank you, I appreciate that. Okay. Because what the author writes is interesting, and it's an article that, of course, somebody's authored. I had the privilege of authoring a law review article that was published. But that's not the law. And Hoffman versus Jones in 1973 said we're abolishing contributory negligence and we're adopting comparative negligence, where we compare the negligence of one party to the negligence of another party. And if you look at the standard jury instructions that the Supreme Court publishes, and of course the Supreme Court says, well, they may not always be right, that's up to the court, but the question is, was there negligence on the part of the parties
that contributed to the loss, injury, or damage, right?
That contributed, but not what is the percentage of the damages that were caused by the negligence. That's what he's writing. Everybody's entitled to their opinion, but
do you think, look, in one way, I see that this would damage you, because if you could argue that, just all the things that were kept out of evidence, it would make what the defendant did here, morally more repugnant, and really, perhaps decrease the amount of your client's comparative negligence that the jury would assess. But do you think that involves too much? Why doesn't that involve too much subjectivity in the decision of comparative negligence? Because one jury, it's going to vary from jury to jury, and it's less subject to cold, rational analysis of causation.
Well, the exact same issue could happen with causation. In fact, in this case, there was no allocation. Nobody said, had she been wearing a helmet, she might have only been 10% injured or something like that. They said it was 100%. But I think we go to the Florida Supreme Court and we go to Ridley versus Safety Clean. Because what they did in that case is they said, you know what? What we're doing now under Pasek Harness is we are first taking, was there negligence, which was a legal cause, and allocating that. And then secondly, we're taking what would have been prevented, which is what the law review article is saying. And what is that allocation? And we're double dipping. And the Florida Supreme Court said that is an unfair analysis. So the Florida Supreme Court has lent lent credence to Judge Schwartz's opinion in the Cox case. That is the better opinion, because the jurors have to sit there and decide how negligent was somebody in creating this loss. And that's where all the other facts that we were discussing before come into play in this case. So I think that the writer has an opinion. It's not the law in the state. It's not the law of comparative negligence. Never has and is not at this point.
Okay, I think we need to hear from your opponent at this point. Mr. Bowman, did you have any questions? Okay, and we'll save you 2 minutes for rebuttal. Morning.
Morning. May it please the court. I'm Warren Kwabnik on behalf of Christopher Besora, the defendant below. Let me begin with the issue that I think the court has expressed interest in. And it would be an interesting question, should the jury be apportioning negligence or blame, or should they be apportioning causation? But it's not an issue in this case. We had an agreed-upon verdict form in this case, and agreed-upon jury instructions. They're not challenging the formulation of the instruction, and it was not the standard instruction in verdict form in this case. Let me read to the court what the jury was asked to do. The jury was asked to determine whether it was negligent for the plaintiff to not wear a helmet. Then they were asked to please state the percentage of loss, injury, or damage sustained by plaintiff associated with her failure to wear a helmet. The jury wasn't asked to apportion negligence or blame or moral culpability. They were not asked to do that. The standard instruction asks for an allocation of negligence. This was an agreed-upon verdict form that asked for an allocation of damages. That was agreed upon by them. And the associated jury instruction said the same thing. So first of all, they were arguing how they made a selection of issues on appeal. It's true. We did argue the existence of this helmet defense. It was the subject of a summary judgment hearing early in the proceedings.
Why was it not error for the trial court to decline to give the instruction on the statute?
Well, again, that's not an issue raised on appeal. It is waived. And this is, again, something that was addressed in the trial court, not argued on appeal, but I can tell you my recollection was we had case law for the proposition that it's error to instruct the jury that a statute doesn't require that they do something, because it could still be found to be a matter of common law duty to take steps for your own precautions. You can be comparatively negligent, or you can be contributorily or comparatively negligent for not doing something, even if a statute doesn't require you to do it.
Let me pose a question to you. A person is injured in an automobile accident, and assuming that the other party is going to be determined to be primarily or sometimes 100% liable for or negligent, and then that injured person goes to Dr. X and gets treatment and doesn't get very much better. And at trial, the defense wants to introduce evidence that had she gone to Dr. Y, who is a much better doctor, she would have had a much better result because all of his patients get better 100% of the time. Would that be admissible?
I don't know. I thought Your Honor was going to get to a Stewart versus Hertz type situation where inappropriate medical care is deemed to be proximately caused by an initial accident.
That's already embodied in the law, so we don't really have that issue here. But just in terms of comparative fault, or she didn't follow up on all the therapy sessions that the doctor recommended, or she didn't take her medication.
Well, I think that's an appropriate comparative negligence defense. I think it's entirely appropriate.
So we're going to put those issues on a verdict form now and say she didn't do anything to cause the accident. However, you should apportion away some of her fault on the verdict form. You can argue it to the jury, but on the verdict form, and maybe even an instruction from the judge that she's comparatively at fault for not getting better medical care or not being more diligent in following her medical instructions.
I think you can do that. I think there may be case law saying you can do that, but a few points.
I'd love to see it.
Okay, but I would point out again, they're not challenging the existence of the defense. They've chosen not to raise that as an issue on appeal.
I understand that.
And I would remind Your Honor also that we had a common law recognized seatbelt defense in the state before the statute was enacted. The Florida Supreme Court recognized it in Passacarnas before the legislature came in and tweaked.
My recollection is prior to Passacarnas, there was a lot of conflict among the courts in the state as to whether or not that was an actual defense that would be apportioned by the jury.
There was.
I was a trial judge during that era, so I'm sure it came before me more than once.
And Your Honor is correct. And then Passacarnas recognized it as a common law matter. But again, they're not challenging the existence of the helmet defense, so it's gone. And again, if I can get back to the issue that is raised on appeal, the exclusion of these evidentiary issues and the jury instructions, it's important to remember, those things are entirely immaterial to the question that the jury was asked to answer on the agreed-upon verdict form. The jury was not asked to allocate negligence or blame in this case. They were asked to allocate the damages associated with the failure to wear a helmet. That's what they were asked to do. It was an agreed-upon verdict form. They're not challenging it on the appeal because they can't, and in fact, in the reply brief, I think they acknowledge that this was an appropriate verdict form. They try to say that it was the standard one. It was not. If the court looks at the standard one asked for an allocation of negligence. This, by agreement, called for an allocation of damages. So, Judge Gross, I can appreciate that Your Honor is looking at conceptually, should we be allocating causation, should we be allocating blame? It would be a terrific issue if they were appealing the formulation of the issue in this case that was put to the jury, but they're not. It was an agreed-upon verdict form, and I think these issues that otherwise could be thorny are easily rectified when you realize this was the agreed-upon question that the jury was asked to decide.
Let me pose a hypothetical to you. Assuming arguendo that we reverse on some issue for a new trial on some issue, whether it be just on apportionment of liability or damages as well, whether or not it's going to be before Judge Henning again, can they change their approach at a new trial and say, Judge Henning, you were the judge on the prior trial. We did this wrong. We agree we did this wrong. We are no longer agreeing to put apportionment on the verdict form.
Well, that implicates certain law of the case issues, maybe. Certain things that I think were ruled upon. We're going beyond the issues I think that were brief, but I know this.
Well, one of the things we have to look at when we're deciding whether or not we're going to reverse a particular case is what's going to happen when this goes back before the trial court. We don't generally, well, sometimes we tell the trial court what to do, but sometimes, more often than not, we'll just say reverse for a new trial.
Right.
Or reverse for a new trial on liability.
Yeah. My thought would be, I know the Supreme Court has indicated when a case is reversed and sent back, that's not the time to start amending pleadings, changing issues. So I would say, as a matter of, my impression is certain law of the case issues would leave things that could have been and should have been appealed intact. Certain things are going to remain law of the case. Certain things, I suppose, within the court's discretion. I don't know that the court is duty-bound to make every evidentiary ruling the same way. But I think certain issues that were adjudicated, not raised on appeal, are going to be held firm on the retrial, is my impression. And again, I hope I've satisfied the court that given the agreed-upon issue...
Can I interrupt and ask
Sure.
about that? I'm not really grasping that point that you're making. In other words, I don't really see it, because, on page 19 of your brief, you've got, like, the verdict form.
Yeah.
And it says, the jury was instructed to indicate what percentage of the plaintiff, Abby Chronister's claimed loss, injury, or damage was chargeable to each. And then question 2 asks, please state the percentage of loss, injury, damage sustained by Abby Chronister caused by the negligence of the defendant and the plaintiff.
Right.
It's still, if we're a blameworthiness state, in determining the percentage, it seems to me they have to consider they're entitled to bring out the full amount or the full scope of the defendant's negligence, because you only admitted you said, yeah, we admitted liability, but I think one of the cases says, yeah, you admitted to 1% of liability. In other words, it's sort of like how the jury allocates that percentage. If we're a blameworthiness state, it's one way, and if we're a causation state, you're absolutely right.
Yeah, well, let me try to answer that, Judge, and I think it is a critical way that the issue is formulated on the verdict form, because they were being asked to allocate the injury to the parties, respective parties' negligence. Hers was failure to wear a helmet, and it was made clear that's the only issue of negligence we're placing on her. His was causing the initial collision. I think, frankly, this is an easier thing to allocate, injury, than something as amorphous as blame. But I think it's clear, if you compare this side by side with what is the standard instruction, which asks for an allocation of negligence, this is not that at all. This asks for an allocation of damages, which renders the blameworthiness entirely outside what the jury was asked to do here. I think that's a critical distinction. And they can't say it's the same thing. This was argued about. Probably half of volume 13 of the transcript and also half of volume 15 was arguing about the verdict form, and this question in particular. And then they went home for the night and came in with an agreed-upon verdict form. They understand the significance of this question. This question calls for an allocation of damages. It renders blameworthiness irrelevant, totally irrelevant in this case. So I can understand Your Honor's struggling with what is comparative fault.
But the trouble is it asks it asks them to assign a percentage to the defendant. In other words, to the defendant. And so I don't think they can assign a percentage to the defendant if we follow Cox without considering the full scope of the negligence.
Well, I don't know if I agree with that, first of all.
How would we compare it? How do we get there?
Well, again, they're not challenging the formulation of the verdict form, and it called for an allocation of damages. How does the jury do it? The jury knew that we were accepting full responsibility for the initial collision, and that the only issue of comparison was the damages placed on the failure to wear a helmet. And the jury heard, expert testimony, uncontradicted, by the way, that had she been wearing a helmet, she doesn't suffer irreversible brain damage. The jury heard they didn't have a helmet expert on this, so this was uncontradicted. The jury had good reason to allocate the damages the way they did, and that's what they were asked to allocate. And I think it's clearly not calling for an allocation of blame. In Cox, presumably that was the case. And again, an important, although we don't have to go there based on the agreed upon issue to the jury, Cox was different. Cox involved the slip and fall. They were sharing fault for the incident, and maybe there was an allocation.
I started to go down that when I was preparing for this case, but then the bottom line is, the Supreme Court has really treated these issues as matters of comparative negligence, so we really can't go that way. And Safety-Kleen, Safety-Kleen says, look, it's all comparative negligence. You're still comparing the initial negligence with the subsequent, helmet or seatbelt issue.
Sure, and Judge, I'm loath to go there, given that this was an agreed upon formulation of the issue, and there's no reason to delve into these issues. But I will, because Your Honor is interested in it. And Safety-Kleen did say that for henceforth we're going to deal with this wrapped up as an issue of comparative fault. But if you read the opinion closely, what they're saying is Passakarnas treated the seatbelt as a matter of mitigation of damages. Then the Supreme Court refined it in the statute to say, plaintiffs are getting double hit on this because they're getting hit on damages, they're getting hit the way it's being done. So they said, we're going to put it together, and the jury's going to come back with a single percentage. But what they made clear is they're not changing the fundamental underpinnings of Passakarnas. They said, we're not changing the Passakarnas rule. What they said is the jury is just going to deal with it in a single percentage. And if there's a footnote in the case, I don't recall it, where they give an example, how it would work under the old system, how it would work under the new. And I think that example makes clear that the component of comparative fault that is the seatbelt defense still is an issue of allocation of damages, just like it ever was. And what the court made clear in Ridley is mitigation of damages has been subsumed into comparative negligence, just like things like last clear chance, assumption of risk. So although it's together now with things like causation of the accident, it's still a different aspect of comparative negligence. It calls for an allocation of damages. And again, I really was reluctant to go down this path because it's really something the parties didn't brief. Nowhere the parties went to.
I'm sorry.
Go ahead.
At trial, didn't the defense introduce evidence of the plaintiff's comparative fault?
Well, we had to.
But by introducing the comparative fault, the failure to wear the helmet, the drinking that led to the conscious decision not to wear the helmet, didn't you in fact open the door to evidence of the defendant's fault? That is the failure to have the license, the inexperience as a driver, the medication, the vision issue. Didn't you open the door to those issues? No, let me explain. Well, first of all, they're not arguing that we opened the door to that. That's not an issue. But no, we had admitted. But if you look at comparative fault.
Well, again, they weren't asked to compare blame. But I would tell Your Honor, no, because we had admitted complete responsibility for what we had done. They weren't admitting that the failure to wear a helmet was negligent. We needed to prove that. We needed to prove these things. That's why we had to show that her conduct was negligent. They didn't need to show that ours was negligent.
But who introduced the evidence that she had a couple drinks?
Well, they did.
But that's you did not introduce that?
They introduced it.
Do you think that was relevant to the decision that? Do you think that would have been? It doesn't seem to me that under your theory that even is that decision, whether she had alcohol or not, it just doesn't matter, does it?
Well,
it's whether she had a helmet or not, right?
Well, that was part of it. But there's case law, and again, because they're not appealing the admissibility of the alcohol issue, it wasn't briefed, so we didn't have a chance to present the court with the cases on this. But, I believe we cited the court to some case law indicating, by analogy to the seatbelt offense, you can admit, you can present evidence that an occupant consumed alcohol to show that his decision to not wear a seatbelt was negligent as opposed to some reasonable decision, and that's why we did it. It was understood that if they admitted comparative negligence for failure to wear a helmet, this doesn't come in. But I guess due to, for some preemptive strategic manner, they brought it in, and probably is why they can't appeal the issue now. But we had to present evidence of this to show that her decision to not wear a helmet was negligent, as opposed to something like there was a fire, she had to get somewhere really quick. I mean, theoretically, I guess there could be circumstances where failing to wear a helmet is excusable.
Assuming that you were required or you chose whichever way to bring that evidence in, why would that not make the seatbelt or the safety helmet statute relevant and require the judge to give that instruction?
Well, again, it's not an issue they're appealing, so I'm kind of at a disadvantage in responding to that. They're not appealing the exclusion of that.
They're appealing generally. They asked for several traffic statutes, and the judge refused all of them.
Well, they're not appealing this one. They're appealing the traffic statutes that they're appealing because they pertain to the defendant's fault. They're not appealing the exclusion of that particular statute. And again, it's really not fair for me and my client to have to defend that ruling when it's just not been raised as an issue on appeal. But again, I'll tell the court, I believe we cited the lower court. You can look at, I think it's in the response to the motion for new trial, case law indicating that it's inappropriate to give statutory instructions to suggest that the defendant, a party does not have to do something or other. Because as a matter of a common law duty to take steps for your own protection, you may have a duty to do this. I could tell you, again, with reference to the seatbelt defense, I believe there's case law saying you have a duty to put on a rear seatbelt for your own protection, even though at the time there was no statute saying you needed to do it.
Well, here's the problem I have with that. There was one time, apparently prior to 2002, when this accident occurred, that everyone riding a motorcycle and or motor scooter was required to wear a helmet in Florida. And for whatever reason, I can only guess the legislature abolished that statute, except as, I guess, may still apply to these motor scooters, what is it, under 50 cc's or something like that?
I don't know.
Whatever it is, all right. Your defense was she wouldn't have been hurt, perhaps not at all, but certainly nowhere near as severely as she was, had she been wearing a helmet. Mm-hmm. Why wouldn't it be relevant that she was not required? Would it have been wise? Would it have been good judgment? Would it have been appropriate? Yes, but it wasn't required. Why is that not relevant?
Well, Judge, I'll answer the question, and I'll tell you that just because a statute doesn't require you to do something doesn't mean it's a matter of your common law obligation to take reasonable care for your own safety that you shouldn't do it.
I'm not disagreeing. Why isn't it relevant?
Oh, again, I believe we cited case law to the court saying it's inappropriate to instruct the jury to suggest the absence of a common law duty to do something. But again, Your Honor, I'm really at a disadvantage on this point. They haven't appealed this.
Okay.
And if had they done it, I could have presented Your Honor with all kinds of arguments or alternative grounds to affirm it. They raised 4 issues on appeal. 1 and 2, in my mind, are entirely foreclosed by the agreed upon verdict form issue, calling for an allocation of damages. They're not appealing the existence of the helmet defense. It's just not fair or appropriate for me to have to defend that now. They're not appealing the inclusion of the helmet issue or or anything else along those lines. But because Your Honor has, I know I'm over my time. As far as the remedy goes, because I know the court is considering the first issue, and again, I would urge the court to look at the formulation of the verdict form. It differs substantially from the standard one and calls not for an allocation of blame. But as far as the proper remedy, should the court disagree, this court in, I believe, Greifer versus DiPietro on rehearing said the appropriate remedy would not include a new trial on damages. They haven't included any issue on appeal involving damages. They're saying to get a whole new trial on everything based on the Curry case. As explained in DiPietro, Curry involved a case where there were inflammatory photos that affected both damages and the allocation of fault. Not true here. There's nothing on appeal that they're complaining about damages-wise, none of the issues. And the damages all were all appropriate within the range returned by the jury. In fact, it was a $12 million gross award. Hardly a minimal recovery in a case like this. I'm going to have to rely on my brief for the other issues. I would just remind the court that the jury selection issue is reviewed for a broad abuse of discretion. We rely upon the trial court to assess patterns of speech, like I think. And again, if I could make one last point, page 453 to 454, Juror Prigg responded unequivocally that he would have no difficulty, no reason he couldn't follow the evidence in this case. That distinguishes all of their cases. And I think the court has finally pointed out there would be no real remedy here for the disqualification issue unless the court was going to remand anyway. But there was just no basis to the motion to disqualify given what they allege happened. If there's no other questions.
But do you think, if we did do that, I've just never heard of a judge chatting up one side and about, and it's outside of my realm of experience that a judge chats with one side about the other side's trial strategy. It just is never, it's just never, I'm not familiar with that type of judges that would do that. So isn't that a problem if it's a remand?
Well, let me respond to that. I know I'm way over time, so let me respond to that. First of all, we have to take, although we need to take her allegations as true, my trial counsel says that's not what happened. So that's really the response to that. But assuming we can even call this an ex parte.
But we can't look at that. It's
I understand.
The initial judge, if there's never been a recusal, has got to take those allegations as true.
Ideally, of course, the alleged discussion wouldn't have happened. But this court has held that, first of all, it wasn't truly even an ex parte communication with the plaintiff right there. But even if it was, this court has held that ex parte communications aren't per se grounds for disqualification. And I believe this is probably as innocuous an ex parte as you can have. To say that a lawyer made a confusing closing argument about double dipping, that doesn't pertain to the merits. It doesn't pertain to a past, pending, or future ruling. It's just entirely innocuous, and it couldn't give rise to a reasonable fear that this judge wouldn't be fair. The other point is it's waived. The plaintiff heard it, but sat on it until the verdict came back. And under this court's decisions pertaining to disqualification and other issues, some of those cases involving improper communication with jurors, you can't wait until an unfavorable verdict to make the motion. So it's waived anyway. But again, even assuming this was ex parte, it's about as innocuous as an ex parte can possibly be. So really, I don't find any error for multiple reasons in that ruling. And again, I can't emphasize enough the formulation of the verdict form, which was by agreement in this case, just renders moot all of their issues with regard to the evidence in the jury instructions. So we'd ask that the court affirm.
Thank you. Okay, Mr. Citrin, you have about 2 minutes for rebuttal.
Thank you. How bad is it when the trial judge and the defense counsel engage in banter about the alleged, perhaps incompetence, is what the affidavit implies, of her own attorney? And she is waiting for a jury verdict to return after 7 years. Is she necessarily going to know to bring that up? Is that going to be the first thing on her mind when her attorney walks back in the room? Is going to be, oh, by the way, they were talking about your trial strategy. What's going on? And so, and it certainly wasn't waived because the affidavit says it was brought to counsel's attention immediately after, and it was timely filed.
I don't think timeliness is too much of a problem. I don't speak for the whole panel, but
just respond briefly to the point that the wording of the jury instruction, in fact, not the jury, of the verdict form and the instruction that he has on pages 19 and 20 of his brief, really are phrased in terms of what I've been saying in terms of a causation approach to comparative negligence. It's not, it is different. So you sort of like, why haven't you waived those arguments by the wording of what you asked the jury to find?
Number one, the first thing is your jury instructions verdict form are framed by what evidence comes in. But most importantly, the jury was twice instructed exactly what I'm arguing on the Cox standard. They were instructed in their jury verdict, and they were instructed in the special instructions, the exact opposite of what counsel's arguing. And here's what they were instructed. And it was right on the verdict form. In determining the total amount of damages, you should not make any reductions because of the negligence, if any, of the plaintiff, Abby Chronister. The court will enter a judgment based on your verdict. And if you find the plaintiff, Abby Chronister, was negligent in any degree, the court in entering judgment will reduce the total amount of damages by the percentage of negligence which you find is chargeable to the plaintiff, Abby Chronister, not the percentage of causation. So twice they were instructed, had they not followed that instruction based on the evidence that they had, they would have had to found 0 because the testimony in this case was that she would not have sustained a brain injury, and that was basically 100% of her damages. So how could they have found 1/3 on the defendant's part and 2/3 on her part if they were in fact allocating proximate cause? Jury verdict form and the jury instructions, which you'll see in the record, say the opposite of what counsel said. At best, that one question that he's relying upon for an alleged waiver is ambiguous, it is incomprehensible, and is contrary to 2 other instructions that this jury got. In addition, with regard to the law review article, that gentleman, whoever he is, versus
Or
Dean
lady.
Prosser.
Or lady. I don't know if he identified.
Yes,
you.
exactly. Or versus Dean Prosser on torts and on comparative negligence. So there we have that. And with regard to the alcohol issue, I moved in limine on the alcohol issue, and I followed the evidence code. The evidence code says that if the court makes a firm ruling against me and the judge said, no, alcohol's coming in, well, then I wanted to defer it because now I know I have to deal with it once she filed the motion in limine. The statute was amended, the Florida statute on evidence dealing with the issue of the motion in limine was amended
You
about
haven't appealed that. I mean, in other words, that's not an issue for us on appeal.
Correct. But it is, I did ask for a jury instruction on what the alcohol limit was, and they didn't give me the jury instruction on that she wasn't even under the influence of alcohol to the extent that her faculties were impaired. And finally, with regard to Juror Prigg, the law states that you have to take in light what he says at the end with what he said in the beginning. And if there's any reasonable doubt concerning the impartiality of this juror, you strike him for cause. And this judge did not do that. That issue in and of itself is a reversible error. Thank you very much for your time.
Thank you all. That concludes the court's